A huge Supreme Court move just hit, and a lot of gun owners are already getting the story dead wrong. If you think the court just wiped out every so-called assault weapon ban in America, slow down, because the truth is more complicated, and in some ways, even bigger. Quick question before we continue, are you subscribed yet? Because this is exactly how people get trapped. They hear one viral headline, repeat it to friends, and then make decisions based on bad information. Hit that subscribe button right now, because what I'm about to show you could change how you understand our 15 bans. Magazine bans and the next major Second Amendment fight in this country. Here's what just happened. The Supreme Court did not issue a final ruling striking down assault weapon bans nationwide. That did not happen. What the court actually did in Snope v. Brown was deny review of Maryland's ban on certain rifles, including the AR-15. That means the justices refused to hear the case for now, and Maryland's law stays in place for now. That is the first thing you need to understand. But here's where the story explodes. This was not some calm, quiet denial that means the court is done with the issue. Not even close. Multiple conservative justices publicly signaled serious doubt about these bans. Justice Alito and Justice Gorsuch said they would have taken the Maryland case. Reports on the court's action also said 3 justices indicated they would have granted review in both the Maryland rifle case and the Rhode Island magazine case. And Justice Brett Kavanaugh wrote separately to say the Fourth Circuit's decision upholding Maryland's law is questionable and that the Supreme Court should, and probably will, take up the AR-15 issue soon in the next term or two. Let that sink in for a second. The Supreme Court did not bless these bans forever. It kicked the fight down the road while basically warning the country that this question is still alive, very alive. That is why people online keep throwing around 6-3 language. They are reacting to a visibly split court, with 3 conservatives openly ready to move faster and a 4th conservative, Kavanaugh, saying the issue is likely coming back soon, but do not make this mistake. This was not a final 6-3 merits ruling on whether assault weapon bans are constitutional. It was a denial of review, with strong signals attached. Now, why does that matter to you? Because signals from the Supreme Court shape everything below it. Lower courts read those signals. States read those signals. The Department of Justice reads those signals. Gun rights groups read those signals. And when a justice says millions of Americans own AR-15s and a significant majority of states allow them, that tells you exactly where the next fight is headed. Most people think the story ends with, the court said, no, the truth is the story starts there. Kavanaugh practically put a timer on this issue. He said the court should and presumably will address the AR-15 question soon. Not someday, soon. That matters because lower courts are still split in how they look at these bans. Some say these rifles are protected because they are commonly owned by law-abiding citizens. Others say they are more like military-style weapons and can be banned. That conflict is exactly the kind of thing the Supreme Court usually steps in to settle. And here's the part nobody is talking about enough. The court's refusal to hear the Maryland case came after repeated conferences, which shows the justices were not brushing this issue off in 5 seconds. They were wrestling with it. That means there is pressure inside the court already. When I found that out, I couldn't believe how many headlines skipped that part and jumped straight. 2. Nothing changed. Something did change. The temperature changed. The pressure changed. The signal changed. If you're finding this helpful, imagine what you'll learn in my next video about the exact words that can hurt you when you talk about your firearm to police or investigators. Subscribe so you don't miss it, because the legal fight is one thing, but what you say in real life can be just as dangerous. Now let's get to the second bombshell, because this is where the Department of Justice comes in, and this part is huge. The DOJ filed an amicus brief in the 7th Circuit, not the Supreme Court, in the Illinois rifle and magazine ban challenge. That case involves Illinois law banning certain semi-automatic rifles and magazines. And the DOJ did not sit on the fence. It backed the challengers. Let me break that down in plain English. The federal government told the 7th Circuit that Illinois ban is unconstitutional. The DOJ argued that AR-15s and commonly owned magazines are protected by the Second Amendment because they are in common use by law-abiding citizens for lawful reasons. That is massive. Why? Because the federal government is not just watching from the sidelines, it is actively telling a federal appeals court that this kind of ban should be blocked, and the DOJ did more than make a vague political statement. It made a legal argument with teeth. It said AR-15s do not fall into the kind of unprotected category reserved for weapons like cannons or weapons of mass destruction. It also argued that AR-15s are not especially or uniquely dangerous in the legal sense that would place them outside Second Amendment protection. The brief pointed out that AR-15s are semi-automatic, but so are most handguns. That comparison matters because it attacks one of the main arguments used to defend these bans. Now, this is where it gets really interesting. The Dodge also went after magazine bans. It argued that the magazines targeted by Illinois are also commonly owned and protected. That means the fight is not just about rifles with scary names or scary looks. It is also about the standard magazines millions of Americans already own. So if you thought this was only about one type of rifle, think again. This is about the bigger question of whether states can ban common arms and common accessories simply because lawmakers do not like them. Here's what most people get wrong. They hear Dodge. Brief and assume the Supreme Court has already ruled. No. That is not what happened. This is not the final word. It is a push. A major push. Yes, but still a push. The Dodge filing is in the Seventh Circuit. That means the battle is still moving through the lower courts, but that lower court fight could become the exact vehicle the Supreme Court uses next. Think about how wild this is. On one side, you have states arguing these rifles are too dangerous and too military in character to deserve protection. On the other side, you now have the Department of Justice saying these are among the most common civilian rifles in America and that banning them is flatly unconstitutional. That is not a small disagreement, that is a full collision. Here's a hypothetical example to explain this. Imagine you live in a state where AR-15s are legal today. You hear one viral video saying the Supreme Court just ended all bans, so you assume the issue is settled nationwide. Then you travel to a state with a ban, or you advise a family member there, thinking the law is already dead. That mistake could put someone in serious legal danger. This is exactly why getting the facts right matters. Now, quick legal note, this is educational information, not legal advice. Always consult an attorney for your specific situation. Let me explain why this fight is so important beyond the headlines. The core legal question is simple. Are AR-15s and similar rifles arms protected by the Second Amendment because ordinary law-abiding Americans commonly own them for lawful purposes? If the answer is yes, then broad bans face a major constitutional problem. If the answer is no, states get much more room to ban them. And that is why Kavanaugh's statement mattered so much. He said the challengers have a strong argument because millions of Americans own AR-15s and most states allow them. That goes straight to the common use test that keeps showing up in Second Amendment cases. Most people think courts only care whether a weapon looks scary. The truth is courts are supposed to ask whether it is commonly possessed by law-abiding citizens for lawful purposes. That is a very different question. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the people who get these updates first before the headlines twist them into something they're no. Click subscribe, because when the next major gun case hits, details will matter more than outrage. Now let's talk about where this goes next, because this is the part that could affect all 50 states. First, Maryland's ban is still in force because the Supreme Court did not take the case. Second, Rhode Island's magazine law also survived for now because the court declined review there too. Third, Illinois is now under major pressure because the Dodge has stepped in and told the Seventh Circuit that the state's ban on common rifles and magazines violates the Constitution. But wait, there's something even more important. These cases are building a record for the next Supreme Court showdown. The justices often wait for more lower court decisions before stepping in. That is exactly what Kavanaugh hinted at. He suggested more petitions are coming and that the court will likely address the AR-15 issue in the next term or two. So if you are a gun owner, a content creator, an activist, or just someone trying to stay out of trouble, this is not the time to tune out. This is the time to pay attention. Have you ever wondered why the court would wait on such a big issue? One reason is that the justices may want more opinions from more federal appeals courts before they issue a nationwide answer. Another reason is strategy. Some justices may believe the issue will look even clearer after more courts weigh in. That does not make the fight smaller. It makes the next ruling potentially bigger. Now, imagine two futures. In the first one, the Supreme Court eventually says common semi-automatic rifles like AR-15s are protected arms, and broad bans in states start collapsing. In the second one, the court says states can ban them because of how they function or how they are used in crime. Those are two completely different Americas for gun owners. That is why this issue matters so much. It is not just about one state law. It is about the future line between protected arms and prohibited arms. Here's what I think shocked many people the most. The federal government is now making arguments that line up much more closely with gun rights challengers than with states defending these bans. That changes the mood of the litigation. When the Dodge tells an appeals court that the Second Amendment is not a second-class right and that law-abiding Americans should not be deprived of their full rights, that sends a message far beyond Illinois. Still, do not overread it. The Dodge cannot erase state laws with a press release. It cannot magically void every ban tomorrow. Warning: courts still decide cases. Injunctions still matter. Appeals still matter. And until the Supreme Court issues a real merits ruling on assault weapon bans, states with those laws will keep fighting to enforce them. This information could literally change fast over the next term or two. Subscribe now, because the next major ruling or appellate decision could move this issue overnight, and my next video will break down exactly what you need to watch before the next deadline or court action hits. So here's the bottom line: the Supreme Court did not permanently end all assault weapon bans, not yet. What it did do was leave the fight alive, leave Maryland's law standing for now, and send unmistakable signals that the R-15 issue is headed back to the justices soon. At the same time, the Dodge has jumped into the Illinois case and is openly arguing that bans on R-15s and common magazines violate the Second Amendment. That combination is why this story matters so much. You have a split court signaling future review, a major federal appeals case moving forward, and a Justice Department now pushing against these bans instead of defending them. If you own firearms, follow gun law, or simply care about how far the government can go, this is one of the biggest developing stories in the country. If this script helped you separate hype from reality, hit subscribe right now and stay with this channel. I spend hours digging through these cases so you do not have to guess when the stakes are this H. And remember, this is general educational information, not personal legal advice. If your situation is real and immediate, talk to a qualified attorney in your state before you act.